of the Standing Committee of Justice and Human Rights. For those of you that don't know me, I do have a 2 cue cards. So when you're 30 seconds away from the end, I will raise that. Just have a look. And then when you're out of time, and I don't like cutting people off, just usually ask you to wrap up. So we will have several panelists today. We'll each have 5 minutes for each department. And then after that, you'll go through subsequent rounds of questions from our respective members of the committee. And if you've missed some, you can probably add to some of your testimony during that time when the appropriate question is asked to you. So I will begin by welcoming the Correctional Service of Canada. And I believe one of you, Ms. Gagnon, will be speaking on behalf of that for 5 minutes. Over to you.
It will be my colleague from Public Safety, Chad Westmacott, who will deliver remarks on behalf of us three. Thank you.
Thank you, Chair. Hello, my name is Chad Westmacott. I'm the Director General from Community Safety, Corrections, and Criminal Justice from Public Safety. We're pleased to be here today to share with you the work of Public Safety Canada's portfolio agencies with respect to our work to support the implementation of Canadian Victims' Bills of Rights Act, or the CVBR. I'm joined today by my colleagues Ian Broome and Kirsten Gagnon from Correctional Services Canada and the Parole Board of Canada. Who also have roles to play in upholding victims' rights under the CVBR. Public Safety Canada is responsible for the Corrections and Conditional Release Act, which guides CSC and PBC in how federal sentences of 2 years or more are carried out and gives life to the rights ascribed to victims of federal offenders under the CVBR. Within public safety, the National Office for Victims is a resource working to improve victims' interactions with the federal corrections and conditional release system by working closely with Justice Canada and applying a victim's lens during federal correctional policy development, developing information products regarding federal corrections and conditional release, and coordinating with its partners at CSC and PBC. These agencies provide registered victims with information about the federal offender who harmed them, assist victims in submitting impact statements to be considered in decision-making, and facilitate victim attendance at parole hearings. As mentioned earlier, in support of victims' rights to information, the National Office for Victims and its agency partners have developed a number of information products to ensure victims are aware of their rights and the services provided to them by the federal government. We continuously strive to improve these products and develop new ones with feedback from victims. For example, we recently launched several information products that explain basic sentence calculation rules for federal offenders, including how eligibility dates for various types of releases are determined. Since 2015, the National Office for Victims has distributed over 80,000 physical copies of its publications. The CVBR established a means by which victims can complain directly to federal departments and agencies if they feel their rights have been denied or infringed. Should a victim not be satisfied with the outcome of a complaint, they can contact the Office of the Federal Ombudsman for Victims of Crime. To increase transparency of the complaint process, the National Office for Victims, in collaboration with its portfolio partners, prepares an annual report which compiles standardized information on complaints and how they were resolved in order to monitor new and emerging trends, address any systemic issues in policy and processes, and identify opportunities for greater coordination to reduce the administrative burden on victims of crime. Since the coming into force of the CVBR in 2015, the National Office for Victims has held 4 national roundtables to discuss with stakeholders the implementation of the CVBR within federal corrections and the conditional release system. Themes raised at these tables were broad-ranging. They included accountability, offender reintegration, restorative justice, and outreach and engagement. Importantly, we heard that information is essential for victims to be able to exercise their rights to participation and protection. In 2020-21, CSC and PBC engaged with over 8,700 registered victims to ensure that they are aware of the services and opportunities available to them. CSC tailors its services at the request of each registered victim, including through their online portal. In each year, CSC's victim services officers complete close to 40,000 notifications about offender-related events. The public safety portfolio is committed to implementing the CVBR to ensure victims of federal offenders are treated with compassion and respect, including receiving timely information required to exercise their CVBR rights. To ensure that Canadians know about the services they may be eligible to receive, CSC continues to undertake public awareness campaigns, including specific efforts to collaborate with Indigenous, Black, and other racialized communities. Victims are also invited to participate in regional victims advisory committees to provide input and advice to corrections and parole authorities. To further consider victims' needs in their operations, PBC established a committee on victims. The mandate of this committee is to provide information and insight on matters of policy and programs, and to enhance the openness of the board through the timely exchange of information with victims on activities undertaken by the board that impact victims. We are always seeking to improve and be responsive to the needs of victims. As such, PS officials continue to review and examine stakeholder suggestions from roundtables, as well as the recommendations contained in the Federal Victim Ombudsman CVBR Progress Report. Thank you today for the opportunity to appear before this committee. Thank you.
Thank you. Thank you for that. I'll now start. Sir, we have more witnesses. I'm gonna. No. We have one presentation, and that would be from the Department of Justice. So I'm going to go over to the Department of Justice for their presentation for 5 minutes.
Thank you, Mr. Chair. I think my colleague, Ms. Bouchard, will deliver our presentation, but just before she does that, I just wanted to alert you and committee members to an additional justice colleague with us, Ms. Susan McDonald, principal researcher from our Research and Stats Division, who will be able to help answer questions as well. Thank you.
Nous vous remercions de nous donner l'occasion.
Thank you for the opportunity to provide information on Justice Canada's measures that support the implementation of the Canadian Victims' Bill of Rights.
Bill C-32, an act to enact the Canadian Victims' Bill of Rights, came into force in 2015. It gives victims of crime statutory rights to information, protection, participation, and to seek restitution at the federal level. The 2015 amendments also included related law reforms on testimonial aids, victim impact statements, restitution, as well as introduced a new community impact statement provision. As required by the Victims' Bill of Rights, Justice Canada has established a complaint process to address any alleged breaches of victims' rights and prepares annual reports on this process. The development of the Canadian Victims' Bill of Rights Act was informed by significant input from the provinces, territories, and broad public engagement, reflecting the shared responsibility for the criminal justice system. As the committee knows, the federal government is responsible for the development of criminal law and procedure, much of which is set out in the Criminal Code. Provincial and territorial governments are principally responsible for the administration of justice, which includes enforcing and prosecuting offenses and providing victim services. Justice Canada supports work on victims' issues through several key initiatives. The department leads the Federal Victims Strategy, which seeks to improve the justice system for victims through funding, law reform, and policy initiatives. Since 2015, almost $78 million in federal funding through the Victims Fund has been invested in provinces and territories to assist them with implementation of the Victims' Bill of Rights, victim-related legislation, and to develop or enhance victim services. For example, funding has been used to support restitution recovery programs, testimonial aids for adults and child victims and witnesses, training on victims' rights, public legal education materials, and building victim services capacity and accessibility. Justice Canada is also supporting innovative victim service model, such as the Family Information Liaison Units, These are culturally grounded and trauma-informed teams that work with family members of missing and murdered Indigenous women. Justice Canada funding is also supporting expanded access to independent legal advice for victims and survivors of sexual assault and intimate partner violence. Criminal code reforms since 2015 have furthered the implementation of the Victims' Bill of Rights. A few examples include in 2018, former Bill C-51 amended the criminal code to clarify and strengthen Canada's sexual assault regime, including building on former Bill C-32 by providing a complainant with the right to counsel during a rape shield provision. In 2019, former Bill C-75 enhanced measures to better protect against and reflect the serious nature of intimate partner violence and strengthen the victim surcharge provisions. Most recently, following the adoption of former Bill C-3 in 2021, be eligible for appointment to Provincial Superior Court, candidates must agree to participate in continuing education on matters related to sexual assault law and social context. Justice Canada continues to support broad research to identify trends, as well as to take note of how victims' rights are exercised in the criminal justice system and the impacts of the Canadian Victims' Bill of Rights. This research informs our ongoing work. Information sharing and awareness raising play a key role in justice system transformation, and to that end, the department continues to support various public legal education opportunities in collaboration with partners. In addition to publishing fact sheets on victims' rights and designing new tools for police and other professionals, Justice Canada hosts National Victims and Survivors of Crime Week, as well as webinars and knowledge exchanges. Victims Week has been a huge success and brings experts together to discuss ways to make our collective commitments to victim more effective. Lastly, I would note that the Office of the Federal Ombudsman for Victims of Crime was created in 2007 and is arm's length from the federal government. The Ombudsman mandate is focused on areas of federal jurisdiction. There have been 3 ombudspersons appointed to date, and a new GIC appointment process is currently underway. In
conclusion, Justice Canada continues to prioritize work to support victims of crime. Implementing the Canadian Victim Bill of Rights continues to be an ongoing process requiring actions from all levels of government working within their areas of responsibility in relation to victims' issues and victims' rights, and significant coordination and collaboration takes place across federal, provincial, territorial networks. We will be pleased to answer your questions.
Thank you. And now we'll go to our first round of questions, beginning with a 6-minute round with Mr. Brock.
Thank you, Mr. Chair, and thank you to all the witnesses for your participation today and your opening statements. It's going to be very helpful to us undertaking this particular study. The focus of my questions and the time that I have allotted will be to justice officials and public safety officials. I won't be addressing anyone in particular, so anyone who is comfortable in answering the question, please chime in. So I've taken an opportunity of reviewing some of the progress reports that were prepared by the former federal ombudsman. And specifically, I took a look at her progress report. And I couldn't agree more when she stated that the adoption of a law in books is different from its implementation and action. Putting victims first in every concept is putting into practice is far more difficult. That the adversarial justice system relegates victims to roles of observers or witnesses in proceedings between state and accused. That the Department of Justice acknowledged that victims often feel re-victimized under the current system and agree that major changes are needed to support rights of victims. As a former Crown prosecutor, I have seen firsthand the disconnect in terms of swaying the pendulum between protecting the rights of the accused at the expense of victims and not ensuring that they are properly informed, that they have a right to a proper information from not only the police, but from Crown prosecutors, and full participation in the process. So bearing in mind the report, the progress report from the former federal ombudsman, I'd like to know from a department perspective what changes have been discussed and what changes are about to be implemented to strengthen the Victims' Bill of Rights.
Maybe I can start with that question, and thank you for the question. In terms of one of the earlier comments you made is the importance of taking what's in the law and then transitioning it to application, and we certainly agree with that statement. It's critically important that the laws that are developed be implemented in a comprehensive way. First point. I think the second point I'd note, as you know, responsibility for victim services is shared across all jurisdictions. So for our part, and my colleagues can speak to that more specifically, we, through our federal victim strategy, through our funding agreements with the provinces and territories, try to support them in their responsibilities for administering justice and supporting victims. Last point, very quickly, I would note is certainly with this review of the Victims' Bill of Rights, we're taking note of all suggestions from your committee in terms of reforms that are needed. Obviously, pay close attention to the reports of the Ombudsman as well, and use all of that information to support the work that we do in providing advice to the government on ways to strengthen responses to victims.
Any other witnesses wish to respond?
If I may, Chair, thank you very much. Just a few different elements on this one as well. I mean, there have been a number of amendments that have been put into place into the CCRA for requiring different actions, both from our correctional partners and our parole board partners, to ensure that victims have a significant role in the criminal justice system, including receiving the information that they require and opportunities to provide input into the decision-making mechanisms that are in play.
Okay.
I'd also further like to add about the roundtables that I mentioned in the speech, which allows an opportunity for victims and victims groups to provide input into public safety and partners in terms of the best way to implement the CVBR, and we take those recommendations into account. Thank you.
As a former prosecutor, I've always took pride in establishing a trust relationship between the victim of crime and my office as a Crown prosecutor. That view was not always shared by my colleagues. From a department perspective, in light of the recommendations regarding training and ongoing education, I know that one of the witnesses who last gave an opening statement spoke about some of the changes that were made in terms of mandatory legal training for our judicial participants. Any recommendations insofar as liaising with the provinces to strengthen the Crown system to ensure that there is mandated training so that there is a consistent level of execution in how we deal with victims of crime, particularly in the domestic context?
I think we always, thank you for the question. I think we always try to find ways to support the enhancement of effective criminal justice system responses for victims. So whether that be through the work that we do with FPT directors responsible for victim services, whether that be through our work with senior criminal justice officials, or whether that be in collaboration with our federal prosecution service and directors of prosecution services across Canada. There are always those opportunities that we seek to maximize to enhance more effective victim service responses, as I say, and more meaningful responses for victims.
Thank you. Thank you, Mr. Taylor. Yeah. Thank you, Mr. Brock. Over to you, Ms. Diab, for 6 minutes.
Thank you very much, Mr. Chair. Thank you very much for the witnesses. Recognize the important work that you all do in advancing the rights of victims. This is not a perfect perfect world, and obviously it's one that is usually intense for all parties. So on behalf of the victims as well as others that get caught up in the justice system or the correctional system, thank you for everything that you do. Just a couple of questions on the Parole Board of Canada established a Victim Advisory Committee, and the Correctional Service of Canada launched an internal victim engagement task team. Can you explain how these initiatives are currently working to provide victims with greater support? And I'll just go a bit further. Anything that you can shed into as a subsequent, and it could be for a different party answering that. Just the relationship between provincial and territorial and your counterparts in other provinces in relation to victims advisory or services or things like that you support, and also in terms of diverse communities. Do you have a lens on that? And if so, what is it, and how do you carry that for diverse communities, people that have perhaps different language than English or French, cultural, but also other communities like Indigenous in my Nova Scotia province, for example, African Black Nova Scotians, and various other diverse communities. Don't know who to address it to, so thanks for, go ahead.
Wonderful. I'm from the Correctional Service of Canada. Just to address a few parts of your question, it's really important to us to treat victims of crime and their survivors and their families with courtesy, compassion, and respect, and make sure that throughout the criminal justice process and throughout an offender's sentence that they have an opportunity for information and to participate in the process. So a few ways we do that. We engage with victims through a comprehensive outreach strategy that we put in place a few years ago, and that includes outreach to Indigenous, Black, and other racialized communities to be able to reach them and make them available of our services. Part of getting them to register for information is making them aware of what's available. In addition to the work we do with provinces and territories to reduce any gaps or to streamline any offerings with those provinces and territories. And there are some examples of that in British Columbia, for example, on the form when folks apply for victim services, they have an opportunity to tick a box to also be engaged by Correctional Service of Canada, so that there's one less step there for them to receive our services as well. Secondly, I would say we have regional victim advisory committees in 5 regions across Canada. These are victims that sit on these committees in addition to management and others, and they do help us provide seek advice and get their involvement in the process throughout. Thirdly, we get ongoing feedback from victims through our victim services officers who are trained through a trauma-based approach. Our parole officers also do receive training on victims so that there's greater alignment. We also get that feedback through our complaint mechanism. We do have very few complaints that come through that process. I think last year it was 10 out of 40,000 contacts. So the program is doing quite well in terms of receiving that ongoing feedback, but there's always more work to do. We are also embarking on doing a survey of victims with the Parole Board of Canada to further analyze our services and see if there's additional gaps and things that we can do for victims, both to be able to reach them and ensure that they have what they need to participate in the process.
Okay, thank you.
If I could,
sorry, go ahead.
If I could follow on that from the perspective of the Parole Board of Canada. Now, if I recall, that you'd asked about our PBC Committee on Victims. So I'd just like to provide a little bit on that. So this committee provides information and insight directly to the chairperson on matters of policy and programs to enhance the openness of the board through the timely exchange of information with victims on activities undertaken by the board that could impact victims, and also to, if I could speak a little bit to outreach. So
To ensure that victims are included in the conditional release process and are aware of the services available to them, the board regularly delivers outreach sessions across Canada to victim service agencies and victims themselves. We've also increased our efforts to reach out to racialized and Indigenous victims in particular. In 2020-2021, the Parole Board delivered or participated in approximately 65 victim-related outreach events across the country with both community and government partners. And we also have a number of victim-specific communication products that are targeted to victims. For example, we'll be launching a new victim services video next month to provide victims with up-to-date and easily accessible information, how they can participate in the conditional release process and the services available to them. Just wanted to add those items from the board.
Still have some time? No? Okay. Thank you very much.
Thank you, Ms. Diab. I'll next go to Mr. Fortin for 6 minutes.
Merci.
Thank you, Mr. Chair. I'd like to thank all of the witnesses here today. I know some of you were there last spring. It's a second time that you're contributing, so thank you. I think it's always helpful. Ms. Bouchard, from the Department of Justice, I'd like to begin with you. Could you inform me of the amounts transferred to the provinces to manage programs in the area of protecting victims for victims' rights? Do you have numbers? I think I'd discussed that with you last June. Do you have numbers to give us on the amounts transferred? Hello. Yes, I was there in June, but this time my colleague Cindy Fuss, who is the manager of the Victims Program, is with us and can provide the amounts, the information you've asked for. I'll give her the floor. Thank you. Thank you, Stephanie. There's a number of aspects where we fund the provinces and territories, especially for the implementation of services for victims, as well as the Charter, the Bill of Rights rather, the Canadian Victims Bill of Rights, and the liaison units for information provided to families of murdered and missing Indigenous women, as well as funding for legal counsels for victims of sexual assault and intimate partner violence. So at this time, since 2015, we can say that we've provided $38 million to the provinces and territories for the implementation, for the improvement of services to victims. Ms. Fuss, I'm sorry to interrupt you. We don't have much time. I'd like to know, do you have a breakdown by province? I know it's $38 million for all provinces and territories, but you don't have it broken down by province? No, but I can certainly provide that information. Oh, by program? You've listed a number of programs. Yes. So that's how I began. That amount is to improve victim services. For the Bill of Rights, it's $13 million since 2015 for the provinces and territories. For the liaison units for information for families, it's $23 million since 2015. And for funding for legal counsel over the next 5 years, it's an investment of $32 million. Will you be able to send me the numbers broken down by program and province? Yes, absolutely. Thanks, I appreciate that. Regarding this issue, I'd like to speak to Ms. Bouchard from the Department of Justice. Within the framework of your reflections on the program and the Act, have you looked at the possibility of considering families of people found guilty? Could they be indirect victims of crime? Because the children who are 10, 12 years old, if they're in school and dad is convicted of murder or something else, there must be significant impacts, at least psychologically. Has that ever been considered as part of under the programs implemented under the Act?
Bonjour.
Hello. Under the law currently, the definition of victims is in Section 2 for the Canadian Victims Bill of Rights and in the Criminal Code. So a victim is a person who was a victim of a crime against them, whether it's emotional or physical suffering or damage to their property. So if a child's parents are incarcerated and there hasn't been violence against them, the fact that their parents are incarcerated does not make them victims of crime under the Canadian Victims Bill of Rights or under the Criminal Code. Perhaps my colleagues at Public Safety would be able to provide further information on tools in place to help families of people who are incarcerated. Thank you, Ms. Bouchard. But I understand that it's not the case currently. Indirect victims aren't considered under the Charter or the Bill of Rights. Have you ever considered including them in the definition of victims, the indirect victims of crime?
J'imagine que le silence veut dire...
I imagine silence means no. I'm reflecting. But for now, the question was raised in June and once again now. So we'll look at that based on recommendations. As my colleague Matt said earlier, we'll look at the information, but for now, based on current law, no, they're not included. Would there be another witness who would like to speak to this issue at Public Safety?
Mr. Fortin, the time is...
I'm over.
Thank you.
My God. Okay, merci. Vite.
I'm sure you'll have another round. For 6 minutes to Mr. Garrison.
Thank you very much, Mr. Chair. And thanks to all the witnesses for being with us today. I want to start by asking a question about who currently avails themselves of the services of the offices of victims. Because I understand from previous testimony I've heard here in this committee in the last Parliament, and also from experience in my own riding, that it tends to be that it's white middle-class people who get served, and that marginalized people, Indigenous people, people who live in poverty, not by intention, but by the structural challenges they face, often don't find out that these services are available, or they're hesitant to access the services because of previous experience with policing and other parts of the system. So I wonder if there's been any work done on who's actually accessing the existing programs and how we can do a better job of reaching the more marginalized. And maybe that goes to public safety as where the office is lodged.
Sure. Thank you very.
Go ahead.
Go. All right. So I'll start. Just in terms of there's a difference, I think, between the National Office for Victims and then those victims that avail themselves of the services of the Parole Board and the CSC in terms of being able to obtain information about specific offenders or specific court cases. But I'll start just first on the National Office of Victims. Over the number of years, as I had mentioned, there's been 80,000 publications that have been given out in terms of hard copies, and as well as significant access to the website that provides information on the rights that victims have under the CVBR, as well as a variety of information about the correctional system, including most recently some fact sheets about how sentences are determined. So that provides victims with information about how they can access the services available to them, but also to better understand the to better understand the correctional system. There are a number of registered victims, as I mentioned in my speech, with over 8,700 registered victims to access the services of the CSC and the PBC in terms of information. And I can also turn to either my colleagues, Kristen or Ian. Maybe I'll start with Kristen, see if they have additional information to add.
I would just add that we do collect this data around different ethnocultural groups and Indigenous groups as well. And it is predominantly white. However, there are some across other ethnocultural groups as well. And that's something that we've made a focus of our national outreach strategy, is to target Indigenous, Black, and racialized groups because they can be affected by crime at a higher rate. And we want to make sure we reach them through a variety of means, through also intermediaries, organizations. We do a lot of social media. We are reaching out through Crown prosecutors. We are using the tools at our disposal to be able to reach those individuals and make them aware of our services to register. It's also one of the initiatives in CSC's anti-racism framework and action plan in terms of a priority. I'll let you add, Ian.
I would just add that for the parole board as well, the focus is on outreach to those groups and ensure that folks are aware of the information services and the opportunity to participate from the parole board perspective. We do have a working group on diversity and systemic racism, where this is part of the considerations that this group has underway. And in addition to the chairperson has a chairperson's Indigenous circle, and the topic of how to most effectively undertake engagement and opportunities to improve outreach has been discussed with that group as well. So we're always striving to ensure that we do enhance the outreach and do reach those marginalized populations. Thanks.
I'm happy to hear
Chair,
this discussion.
If I may just...
Sorry, go ahead.
I was just going to say, Chair, if I may just add one more item. In the information documentation that I was referring to from the National Office for Victims, I did want to just flag that some of our publications are available in 20 languages, including 7 Indigenous languages. Thank you.
Great, because I'm very happy to hear there's some active outreach and awareness of the problem of outreach. But I also think that those who live in poverty, no matter what their background, are disproportionately victims of crime. And they're also the people least likely to have access on a regular basis to the internet or information that's online. So I just hope when you're doing these things that there's some attention paid to that. I'm not sure how much time I have, Mr. Chair, but I do want to start on the question of language rights. In our criminal justice system, we guarantee language rights of the accused, but we don't do anything that I can see in victims' rights to guarantee that victims have access to supports when proceedings, either court proceedings or parole proceedings, take place in something that's not their first language. So I just wonder if there's some attention being given to the language rights of those who are victims of crime, since we do a pretty good job on the other side.
Very briefly, please.
Yes, I can just add that, yes, we do. We also distribute hard copies, but I will also add that plain language is also really important for reaching victims, especially people who are traumatized, to be able to make clear what's available and how to access it, and then provide the choices and options. Ian, I see you had something as well.
Unfortunately, I'm going to have to cut you off there. Hopefully, we'll get back to you. I also just want to remind, I think there was talk before about submitting something when Mr. Fortin was asking. Any information you have to send, please send it to the clerk, and then the clerk will distribute it to everyone. Next, we have Mr. Cooper for 5 minutes.
Thank you, Mr. Chair, and thank you to the witnesses. I will address my questions, whoever is in the best position to respond from either Correctional Service of Canada or the Parole Board, or frankly, Public Safety. I think it was the official from Public Safety who stated a few moments ago that there were some 8,700 victims who were registered to receive information, but as of 2018-2019, there were some 23,000 offenders under federal responsibility. I presume that number has not changed significantly. So there's quite a considerable gap between the number of persons who are incarcerated and the number of victims who have registered for information, which, as the former federal ombudsman for victims of crime, Heidi Illingworth, emphasized, is a foundational right. Without it, victims cannot effectively assert other rights. So could any of the officials speak to that gap between the relatively small number of victims who have registered relative to the number of persons incarcerated in federal custody?
Well, I'll start off and then potentially turn to my colleagues. I would just point out that, the registration requirement by CSC and PBC to receive information ensures that information is provided to individuals who meet the legislated definition of a victim, and only those victims who desire continued contact following convictions are notified. This is a trauma-informed response, which respects the choice of victims who wish no further involvement with the criminal justice and corrections system regarding the offender. So it is not every victim that wants to receive the information that is available to them through the CVBR. I'm not sure if my colleagues from PBC or CSE would like to add something.
I can just reiterate that it's definitely not a one-size-fits-all approach. We try to customize, the information that we provide based on the interests of those victims. And some victims don't want to register to receive information, and that's their choice. But if they change their mind at any time in the process, of course, they're able to register and provide victim statements, et cetera, at any point in time and participate in the process. But also, I think through active outreach, we'll be able to reach more people, to make them aware and to remind them that we're there to provide these services. And that's what we're mandated to do under the law as well.
Thank you for that. Now, in the January 2021 report from the Federal Ombudsman for Victims of Crime entitled Information as a Gateway Right, the Ombudsman found that the requirement of self-registration is problematic, and that victims who perhaps would like to receive information but don't have the information, aren't familiar with the process, don't know how to self-register, are left out. And it is her recommendation that rather than providing for self-registration, that instead victims should be automatically registered with an opt-out. Have you given some thought to the recommendation of the former ombudsman?
Thank you very much for that question. It goes to what I was saying earlier, is that we really want to take a trauma-informed response that respects the choice of the victims. And so moving to an automated or automated system where the victims automatically receive information does not respect that trauma-informed response or the choice of victims. It's very important that victims have that opportunity to decide if they want to receive that information or have the ability to not receive that information if they do not want to receive it. In order to ensure that victims have the available information to them in terms of how registering, that is one of the key pieces of information that is distributed and available through the National Office for Victims in terms of how to register and how to receive that information. And as I mentioned, that information is available both in hard copies for free of charge, plus available on the website and in a number of different languages. Thank you.
Thank you, Mr. Cooper. Next for 5 minutes, Madam Dillon.
Thank you, Mr. Chair. I'd like to focus my questions on discrimination against marginalized people. we see it often within the criminal justice system itself. So my first question, it will be to Mrs. Bouchard. You spoke about matters coming before the ombudsperson. Can you please explain to the committee how many of these issues or complaints regard racism in the system, and whether it comes from the victim side, the offender side, or both, and how are these resolved? Thank you.
Hello. I believe you were referring to my remarks in where I speak about the justice complaint mechanism that we developed after the coming into force of the CVBR. So I can't speak to all the different questions and data that you specifically asked for, if we have the numbers for all the various types of complaints. What I can say is all our annual reports are published online. And so far, since 2015, there's only been 2 CVBR complaints that have met that were found to meet the complaint mechanism that exists for Justice Canada. One thing to remember is Justice doesn't provide direct services to victims of crime. So mostly complaints and information relate to the right to information and to the parole board funding that's provided through the Victims Fund to permit victims to assist parole board hearings. Mostly the inquiries that we receive relate to PT administration of justice or various complaints. So we make an effort to respond to each inquiry that comes through the complaints mechanism and provide them with information regarding where they can access the proper source for information, either directly to PT Victim Services or through the, we have a Victim Services directory that's available on our website that permits victims to enter their postal code and find the resources that are near them.
I can just add for,
go ahead.
Pardon me. Just for Correctional Service Canada, we have a complaint process as well, and we did receive 10 complaints last year, over 40,000 contacts, so very few. They mainly relate to rights, so information protection, participation, and those who seek restitution, not about racism.
Perfect, thank you so much. And there's both the PBC and CSC have regional advisory committees. There's, with such an approach where you sort of get victims to volunteer to be on these committees, can you please tell us what the percentage is of marginalized people who sit on these committees? And if you don't have that information, could you please provide it to the committee after? Thank you.
I don't have that with me, but I'm happy to provide it, yes.
Perfect. How many minutes? 2 minutes. Okay, perfect. So, Mr. Westmacott, you spoke about offender reintegration. Can you tell us what criteria is looked at when this happens and the determination that is usually made? Thank you.
I'm sorry, could you clarify a little bit more in terms of what context about offender reintegration?
You spoke about offender reintegration, and I wanted to just hear a little bit more about that, if you could elaborate on the criteria or any further information you can give us. Thank you.
I'll turn to my colleague from CSC for conversations around the criteria around offender reintegration.
I'll try to tackle that one as best I can. We do a number of things around offender reintegration, including the work that the parole officer does in the community to ensure adequate supervision of offenders who are released into the community. One of the things that was raised earlier, if I may use this opportunity to address the question on the national task team that we have in place, we are doing quite a bit of work with our operations group and victim services to try to bridge any gaps between offenders that are on release or temporary absences within the community to be able to look at how we're delivering on those operational aspects and see if there's anything more we can do around upholding the Victims' Bill of Rights in that decision making, prevent negative reactions from victims, for example, in case management decisions, and also improve on collaboration at all levels, regional, national, and local, so we can incorporate victims' concerns in our decisions.
Thank you, Ms. Gagnon. Next, for 2.5 minutes, for Mr. Fortin, please.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I'll use these precious 2.5 minutes to ask from the Department of Justice, what was planned for restorative measures for reparation? There's the criminal justice system where the accused goes to prison or suffers consequences. But are there any restorative measures to reconcile the victim of crime with the accused? Sometimes it's not possible, of course. I wouldn't ask for a rapist to meet a victim, but there are surely some restorative measures that could be looked at to correct behavior and also signify to the victim that we care about him or her, that we're not just there to condemn the accused, but that the system is also there to walk alongside the victim through this difficult process and possibly turn the page on the crime they were a victim of.
Oui, en effet, merci.
Yes, thank you. I'll answer for Correctional Service of Canada. We have a restorative justice program, and we've had it for 20 years. It's been a very successful program. We really believe in it. It's a voluntary program, however. Victims and inmates have to want to participate in a process, and we really take the time to design a process to meet the needs and goals of each one. It can be very powerful as a mechanism. We've never refused anyone who wants to participate in our program. And we do a lot of work at the federal, provincial level and with the territories. Ms. Gagnon, I'll be impolite, but we don't have much time. I just have 30 seconds left. I understand that there's that voluntary system, but I was wondering, has it been looked at that a sentence could be reduced if the accused agrees to meet different restorative measures? Is there something like that to really promote restorative measures in the justice system?
Mr. Fortin,
Mr. Fortin, I'll try to answer your question, but I'll speak English because I can do so more quickly.
Section 717 of the Criminal Code does contemplate alternative measures, restorative justice processes. Those can happen at different places. They can happen pre-charge, they can happen post-charge, and they can also happen as part of the sentencing process. So there are those opportunities within the criminal justice system currently to facilitate the restorative justice sentences. In terms of the imposition of a sentence, a judge is always required to impose a fit sentence based on all of the particular circumstances surrounding the case.
Thank you, Mr. Taylor. And now for 2.5 minutes to Mr. Garrison.
Thank you very much, Mr. Chair. I want to follow up on the excellent questions from Mr. Cooper on the gap between the number of victims registered and the number of offenders. And while I think there will always be a gap, many victims may not want to avail themselves of services. I think what Mr. Cooper was asking about is, I guess Mr. Westacott, is that how do we know that victims are making a choice if they don't know they have a choice? So if they don't ever receive the initial information about what rights or services they might receive, how do we know they're actually making an informed choice? And I know Mr. Westacott talked about respecting the rights of that choice, but I think the question was really more about how do we know they can actually make a choice if they don't have that information?
Thank you very much for that question. There's a lot of work done to make sure that the information is available so that victims are aware of the rights that they have and the ability that they have to obtain information, including through promotion through the National Victims Week and through the various steps along the criminal justice system. I will also turn to my colleague, Kirsten, who may have something to add.
I just wanted to add that over the past 2 years, we did see a 10% increase in our registered victims. So it's a trend in the right direction. We do know during COVID, the website traffic is up, I believe, almost 22%. So I think there's some good indicators there that more people are accessing service, I think in a virtual way as well. And maybe PBC has something to say about that. But definitely a trending in the right direction. But no, currently we don't require mandatory registration.
Thanks very much.
I'm sorry.
Well, I just want to, sorry, I am going to cut you off. I was going to ask a different question. I want to ask it, and it's going to be to you at Parole. I have an institution in my riding where lots of people do end up going for parole. And during COVID, we found many victims were having trouble attending those hearings or getting information about those hearings, and they were actually being denied effectively their rights to participate. And I don't think, again, this was intentional, but I just wonder how you've tackled this problem of getting information and allowing victims to participate in those processes when they became virtual.
Oh, I'm happy to respond to that question. Thank you. So I would start just by saying that the board is committed to ensuring that victims' voices are heard, their rights are respected, and that there is the opportunity to participate. However, as you point out, as a result of limited access to CSC institutions at the outset of the pandemic and throughout, depending on the situation in the communities in terms of transmission, PBC hearings were conducted remotely. So in April 2020, the Parole Board implemented an interim solution for victims to participate.
Mr. Broom, I'm going to have to cut you off there, sorry.
Okay.
Over to you, Mr. Morrison, for 5 minutes.
Thank you, Chair. I'm just going to sort of dive into something we haven't really talked a lot about, and that's national standards for the treatment of victims for training. And I guess I'd like to see both sides. We've got justice and we've got public safety. Is there national standards for the treatment of victims right now for, say, the judges, and same with on the public safety side for all the departments there? If there isn't, are you going to develop one? And the last question would be, who's accountable to ensure that people who are in those departments are actually treating victims on a national standard, so they're all treated consistently? It seems we're kind of all over the map a bit, so maybe if each department can just explain a little bit about what you're doing to ensure there's a national standard for the treatment of victims.
Perhaps I can begin, Mr. Morrison. Are you speaking about standards through the Standards Council of Canada, the SCC, and the formal development of national standards?
Well, sure, but I'm also speaking of when we require, like, for example, criminal justice personnel or law enforcement personnel to have continuous training, and part of that training would be, are they aware of how the treatment of victims? Do they know how to treat victims? Maybe we could close that gap from unreported to reported if there was a standard.
I think that the Canadian Statement of Basic Principles addresses that standard, and that has been signed on to by all provinces and territories who are responsible for the administration of justice, and so that falls under their domain. I can turn this over to our public safety and portfolio colleagues to address the issue of standards in their respective agencies.
Thank you very much. I can just very quickly, I'll just jump in and say that there is training available that is done through the Parole Board for their regional communications officers and in the CSC for the victim service officers that helps to ensure consistency in services. And also the complaints process that is set up through the various agencies is a way to ensure that if the services are not provided in a way that a victim feels is appropriate or respects the rights, that there is that opportunity to raise that complaint and concern. I'll turn to my colleague Ian. Or Kirsten, sorry.
Thank you. I just wanted to say that registered victims tend to be those who are affected by most violent crimes. so they may be more seriously harmed. And it's super important to do really good training. We have victim services officers across the country who get regular training. We also have it in the parole officer induction program, and also working with stakeholders on an ongoing basis to get advice on how best to reach victims on an ongoing basis is key. And organizations that are trusted.
Okay, perfect. I think that, I know I didn't get to parole, but I'm going to I just want to move on to one. I'm going to run out of time here. On data and sharing of information between agencies seems to be a consistent issue in not only the federal government, but in a lot of different places. Just reading through some reports, the police, for example, they don't report the number of interactions with victims. Crown prosecutors, their information isn't shared. Courts, review boards, correction services, parole boards, they're almost pretty well the same, where we do not have any sharing of information. And I'm wondering whether or not, and probably more public safety on this because there's more agencies there, how do we correct that?
Thank you for the question. Oh, please go ahead, Kirsten.
I just was going to say, just to kick that one off, that to ensure better protection of the public, our parole officers work with and share information with police agencies across the country in those jurisdictions where offenders are released into the community as a law-abiding citizen. So this helps to ensure public safety on an ongoing basis and protect also victims in those communities.
Okay, and maybe one last question there for public safety. I've only got about 30 seconds. We talked about restorative justice for offenders, which is a great program. I know I've been involved in that, especially on Vancouver Island. Restorative justice for victims, that is really interesting, and I'm wondering if there's federal funding there, same as federal funding for victim services.
Our Restorative Opportunities program is funded through existing funding at CSC. Were you looking for those exact figures? It does include...
Yeah, unfortunately, you're out of time. So if you have those figures, you can send them to the clerk afterwards. Next, for 5 minutes, Madame Briard.
Thank you, Mr. Chair. Hello, everyone. Thank you to the witnesses for joining us today. In the January 2021 report, the Federal Ombudsman wrote that we wanted the Canadian Victims Bill of Rights to provide better access to information for victims and a greater consideration of their safety. However, victims in the Canadian justice system continue to tell the Ombudsman of victims of crime that they are not sufficiently informed of their rights and the services available to them. There's even a recommendation of making a distinction between more factual information regarding different steps of the judicial process, hearings and sentencing and parole, and then informal information like explanations on decisions from judges. How can you explain that difference between the theory and the practice? That's my first question. And then, do you believe the fact that the burden of asking for information is on the victims at each step is an obstacle for them? Anybody can answer. Thank you for the question. I will answer in English.
The right to information, as the Ombudsman has noted in her 2021 report, which she considers a gateway right, I think the right to information, everyone at this table can agree that it's very, very important. Victims have always wanted information. There's an article that we prepared that looks at more closely at this right to information, but particularly in the context of the impact of trauma on learning and what victims are actually, those who are particularly traumatized by their victimization experience, what they're actually able to retain in terms of memory being affected and different strategies for that. The article is called The Right to Information, and it is available, and we can forward that, the links to you. It is available online in both official languages in the Victims of Crime Research Digest 2016. Importantly, what we looked at too was at the outset, even before the Victims' Bill of Rights, Canadian Victims' Bill of Rights came into force, the Department of Justice reached out to key victim stakeholders through the Policy Centre for Victim Issues and conducted a survey to really determine how these stakeholders wanted to learn about the CVBR, what format, what mode, and what particular topics. So exactly as you refer to the factual aspects of how the criminal justice system works, actual specific amendments to the criminal code, etc. And these results came in. We had 604 responses, 38 from individuals, 62 from organizations all across the country, with some really good marching orders in terms of how to get that information out there. That's one aspect of the article, and the other parts talk about research from different fields such as psychology, to really understand the right to information and the particular group of victims. I hope that begins to answer your question. Thank you.
Thank you. Merci.
Thank you. Is it clear for victims who they can obtain information from? It seems to me that sometimes the buck is passed. Is there an issue of confidentiality?
I think what we find that where there are, for example, the Department of Justice supports the development and enhancement of child advocacy centers and has been doing so since 2010. In those instances, child advocacy centers include a multidisciplinary team, and for those teams, protocols, specific information sharing protocols are signed. So law enforcement can share information with others sitting around the table, which might include mental health professionals, medical professionals, advocates, victim services, Crown, for example. And in those cases, the flow of information seems to work very well, particularly where there is a victim advocate who is there to pay attention to the non-offending family member. So, for example, a parent.
Thank you. Thank you, Ms. Briard. Now for 5 minutes to Ms. Findlay, and welcome to the committee today.
Thank you, Mr. Chair. Section 16 of the Canadian Victim Bill of Rights grants victims a right to have the court consider making a restitution order against the offender. Has there been an increase in restitution orders since Section 16 has been in force? Not sure who wants to answer.
I can speak to that, Madam Findlay. We have, the short answer is we're not sure, which sounds very vague and undata-like, and my apologies for that. We have, through special requests, been able to get data from the Canadian Centre for Justice, Community Safety and Justice Statistics at Statistics Canada, and are able to look at data prior to 2015. It's on a fiscal year, so it would be sort of up to 2014-15, and then 2015-16 up to 2019-20. And at this time, looking at both adult and youth court statistics of restitution orders made by type of restitution order, it does not look like there has been an increase. Feedback from provinces and territories from whom the data are collected have indicated that they believe, or they actually say that the numbers provided by our National Statistics Agency are less than what they have at home. We don't quite understand the discrepancies, but we are going to be following up and have meetings scheduled, or we'll be scheduling meetings in the coming months to do so.
It sounds like the process of monitoring isn't very robust, but if you have some of those figures, perhaps you could table them with the committee. How are such orders enforced? Is there, would you suggest changes needed to make enforcement easier for victims?
Enforcement when it is still in the criminal justice system. So when there are restitution orders, a condition of a conditional sentence or probation, community corrections works very closely with the offender to develop a payment regime. For example, a schedule or payment is made at the outset, paid to the court, and then transferred to the victim. In standalone orders, there is no such supervision, which then results in, if the order expires, the onus is on the victim to file that order in civil court and use civil measures for enforcement, which can be very difficult.
Yes,
so
that sounds quite onerous, actually. In 2019, a Declaration of Victim Rights was incorporated into the military justice system through Bill C-77, amending the National Defense Act. Can one of you tell the committee when victims in the military justice system may expect to benefit from the Declaration of Victims' Rights? My understanding is it's been almost 3 years since Royal Assent, and that declaration is still not in force.
Thank you for the question. I think that your committee will be hearing from witnesses from the Department of National Defense, and they'll be better able to answer that question. We understand they're working diligently, and they'll be best placed to provide more information.
My understanding is in testimony in June of 2021, the then federal ombudsman said that critically what we hear from victims, the largest gap in the bill in its current form is that there's no ability to enforce the rights within the Act. So can you suggest what can or should be done to ensure that the rights outlined in Bill C-32 are enforced while continuing to respect the rights of the accused, of course, and convicted offenders?
Maybe I can start, Ms. Finley. I mean, it's a very good question, and we know it's one that's been talked about for many, many years. Our colleagues have already talked about the complaints processes that have been established to address concerns that rights are not being implemented at the federal level. There's corresponding processes in place with provincial partners, provincial victim service agencies, prosecution services. And as the VBR makes clear, it's not meant to take away any pre-existing rights that victims might have to commence, for example, civil proceedings where wrongs have been alleged. I think I'll stop there because I know I don't have a lot of time.
Thank you. Thank you, Mr. Dale. Thank you, Ms. Finley. Next, for 5 minutes to Mr. Zaberi, please.
I'd like to thank all the officials for being here and taking time to discuss this very important issue. I'd like to touch base upon diversity and inclusion for a few moments. When it comes to newly landed communities in Canada, are there outreach efforts being made to help them access supports in particular for communities or those who haven't yet mastered one of the official languages that are still maybe using another language other than those two? Are there outreach efforts to connect with those communities? And if so, can you describe what those are?
Maybe I'll start again. Again, one of the challenges with this area is the shared responsibility, as you know, and so different levels of government responsible for supporting the implementation of victim services. Federally, on the justice side, and you've heard from our colleagues on the public safety side, we try to make information available in different languages to support victims who may not speak English or French. But primarily, we would seek to work with community organizations and our provincial and territorial partners to address those needs that are important, as you've identified.
Just to follow up quickly, community organizations then have people who can communicate in languages other than English and French, just to access those who are living within Canada to help them navigate the system?
I think we would have to get back to you with more specific information on the community organizations that we support and the types of services that they provide in other official languages.
I think we certainly can speak to, sorry if I may just jump in very quickly. We do have a victim services directory, and it includes information on languages spoken and whether there are particular populations. We see this particularly in instances of family violence, where there's a very good network, both of shelters, but also community organizations that will work with victims, whether it is a female in an intimate partner violence situation or violence against the children. We'll work with them and strive to work with them in their own language and understand the particular dynamics and culture from which they come. You may know that in Ottawa, about a year ago, a shelter opened up specifically for Muslim women, the first of its kind in Ottawa. And it's by all accounts been very successful, both in terms of providing information, but also actual service through sheltering.
That's excellent, and to hear and reassuring. While I personally feel strongly that all in Canada should learn at least one, if not both, official languages, but the reality is that not everybody has that capacity at this when they land here, so it takes some time. So it's good to hear that is clearly a partial focus. Continuing on that theme, I'd like to move into trauma and those victims who have suffered some form of trauma. Are there supports for them that are culturally sensitive, or the nuances of various different cultural communities within Canada or life experiences? Can you elaborate a bit more about that?
I can jump in again, and again, using the example of family violence, I think that they're very culturally appropriate, and this is not just for immigrants. We also see this people who are living in Canada but practice a different faith or feel more comfortable with people speaking their mother tongue, for example, as well as Indigenous people. And we see this particularly, I've used the example of family violence, but we also see it in other gender-based violence situations, such as sexual assault, criminal harassment, where there's been a lot of work done in, I would say, at least the last decade, in terms of expanding the provision of services to very specific minority groups. I know that when provinces and territories apply for their funding, and my colleague Cindy Fuss can elaborate on this if you'd like more, that they focus on underserved victims and that victims of minority groups, both in terms of language, race, religion, for example,
Thank you.
are being supported.
Thank you. Now for 2.5 minutes to Mr. Fortin, please.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I'd like to talk to Public Safety, Mr. Westmacott, or Ms. Wallace, I believe. So with Public Safety, regarding the restorative justice measures, what is done currently in our penitentiaries to raise awareness among offenders of the impact of their crimes on victims? What could we do to go further? There are already measures in place, I know that. But just quickly, I only have 2.5 minutes. So perhaps 30, 60 seconds, please be brief. But what exists and what could be done? Is there reflection underway to really try to raise awareness among offenders of the impact of their crimes? Thank you.
I'll turn to my colleague Kirsten for a response on this one.
Yes, just quickly, I think the parole officers play a role, whether it be in the community or the institution, in working with the offenders. And they are one of our referral agents for restorative opportunities and that philosophy behind how we work with inmates. That includes like dynamic security and working through issues within the institutions. I'll just turn it over to Catherine quickly to add some detail.
Every offender as well from their intake it works on a correctional plan that they work through during the course of their sentence, which outlines various programs and options for rehabilitation. Those programs are meant to treat criminogenic factors, but rehabilitation takes more than that. That includes accountability and recognition for their crime. Restorative Opportunities is a specific program for those victims and offenders who'd like to take part in it, and it does have very impactful outcomes. But rehabilitation is, I would say, something that every offender is supported to do so, is working through that through the course of their sentence.
Merci. Est-ce que...
Thank you. Ms. Gagnon, are victims informed of the different restorative measures that the offender is participating in and the impact of those measures on the offender? Are they informed?
Very briefly.
Yes, if they choose to receive that information, we inform them. Okay, but there's not more than that. There aren't measures taken to automatically inform them of the restorative measures or the results.
All have access to, there's an inmate handbook in every institution. There's information available to inmates about restorative justice. Victims are also informed, which was an addition through the CVBR. Victims are all informed as well about about restorative justice and our restorative opportunities program through our victim services officers. So for our program, we get referrals from both offenders and victims.
Thank you. And now for 2.5 minutes to Mr. Garrison, please.
Thank you very much, Mr. Chair. As I've given notice of motion today to deal with another matter, I'm prepared to forego my 2.5 minutes here, as this study will be ongoing, so that we have time to get to my motion, and if the committee will indulge me, a little bit of a preamble to the motion. Thank you. Thank you, Mr. Chair. I've given notice of motion regarding coercive controlling behavior, and I just want to provide a little preamble because we haven't discussed this in a public session in this Parliament of the Justice Committee. 2 years ago, at the beginning of the pandemic, I did one of my regular call-arounds to social service agencies and police agencies, and I learned that one of the first things that happened was a spike in calls for assistance in intimate partner violence. And after discussions with community agencies and the police about how we could best respond, I tabled a private member's bill calling for criminalization of coercive and controlling behavior as a tool for earlier intervention in problematic family situations, and as a potential tool for reducing violence in intimate partner relationships. As I had no luck in private members' draws in the last two parliaments, I asked the Justice Committee if they would consider the issue, and there was unanimous support from all parties, and we held hearings in the last parliament, and they were very important hearings. And one of those most important hearings, I think, most important outcomes of the hearing, I think, bears repeating, and that is, in this country, we still lose one woman every 6 days to intimate partner violence. And so we need more tools and we need more supports to deal with this crisis. At the hearings, we heard how coercive and controlling behavior is in itself a form of violence, but also how that it's almost always a precursor to physical violence. And we heard from a wide variety of witnesses of all kinds that Parliament really needed to take the issue more seriously and needed to act. So almost a year ago, this committee tabled a unanimous report calling for the criminalization of coercive and controlling behavior and improving supports for victims of intimate partner violence. And unfortunately, the election call made that initiative die. And so today, I'm pleased to move my motion, which members received notice of, that this committee retable the Justice Committee's unanimous report on coercive and controlling behavior and ask for a response from the government. I'm anticipating support from all parties. Once again, I know everyone acknowledges this is a crisis, and I think crisis is the right word that we need to respond to. And by doing so, by retabling this report, we'll get this back on the agenda of both the House and the government. Thank you, Mr. Chair.
Thank you. Do we have any debate, or do you wish to go to a vote? Seeing no signs for debate, vote. All in favor? Anyone not in favor? No? No, unanimously consented.
Mr. Chair, can I ask that we record that the vote was unanimous once again, and I thank members of all parties for their support on this important motion.
You're welcome. Thank you, Mr. Garrison. The vote was unanimous. And to all the witnesses, this will conclude the meeting. And want to thank you all and for giving your very important testimony at this committee. And we'll look forward to resuming this study shortly. Thank you. Meeting be adjourned.
Thank you.